Hello, this is attorney Munjongtak from TV. Can we say it? It was just a moment ago. There were many superstitious talks at 11 o'clock on April 4, 2025. There was talk about President Yoon Seok-yeol's baptismal name, and it took quite a long time until the 2024 Hana 8 ruling, which I had predicted. The impeachment request for President Yoon Seok-yeol was accepted, unanimously, by all 8 constitutional judges. He has been removed from office. President Yoon Seok-yeol. This is the second presidential removal, following former President Park Geun-hye. It's a tragedy for our country. However, it could also be seen as the constitutional system still functioning. I had previously uploaded a video about instructor Jeon Han-gil, and I received a lot of criticism at that time. But even then I clearly stated, hope and prediction are different. And I predicted from the beginning that he would be impeached. Do you see the Chinese character today? This is the summary of the ruling. Regarding this ruling summary, I might be the fastest among the lawyers, though some of you might be having a meal, while others might lose their appetite, and not be able to eat. Considering the level of our TV subscribers, which I believe is higher than any other channel, I feel obliged to skip lunch. Also, there's construction going on nearby. So, now that the workers have gone out for lunch, if it gets noisy again, I won't be able to do it, so I'll try to record quickly. I'll quickly summarize the key points and then organize it into a neat video to upload. Let's begin. I'll proceed, as I organize the Hangul file. The legal requirement is that from President Yoon Suk-yeol's side, Attorney Kim Gi-ri, whom I personally know, is asking for dismissal from the respondent's position. Before getting into the merits, the impeachment request is incorrect, so there's no need to judge the merits. Dismiss it, get lost. This is used as an attack method. It's a defense method. To be precise, whether the proclamation of this constitutional amendment is subject to judicial review. If it's not subject to judicial review, it cannot be reviewed. That was the old logic, the old timers. Even senior legal professionals to me used to talk about acts of governance, but that's an old story. The purpose of the impeachment trial is to protect the Constitution from violations by high-ranking officials. Yes, if a high-ranking official violates the Constitution and laws, they would all claim it's an act of governance, right? I was just trying to perform an act of governance. Then you can't prevent violations of the Constitution and laws, can you? Therefore, the purpose of the impeachment trial is to protect the Constitution from this. Saying a constitutional amendment proclamation isn't subject to judicial investigation and should be dismissed doesn't make sense. This is how it turned out. Even if the proclamation of a constitutional amendment requires a high level of political decision-making, we must review whether it violates the Constitution or laws. That's why the Constitutional Court exists. Second, the National Assembly's Legislation and Judiciary Committee. The Legislation and Judiciary Committee deals with legal matters, and Jung Chung-rae is the chairman. Although I am also a lawyer, members of the National Assembly would know a lot about the law. He, not a legal expert, chaired the Legislation and Judiciary Committee, represented the petitioner, and held a press conference today. The committee proceeded with the impeachment proposal and resolution without investigation. So the Legislation and Judiciary Committee should conduct an investigation. But in the US, when they try to impeach, they go through many procedures. In our country, things are a bit urgent. Since you are in a hurry, I am also quickly proceeding without even having lunch. Isn't doing this without an investigation a violation of the requirement for legality? They should resolve the impeachment proposal after conducting an investigation. However, the Constitution leaves the impeachment procedure to the legislature. Legislation occurs in the National Assembly. The National Assembly Act states it like this. The decision to investigate by the Judiciary Committee is at the discretion of the National Assembly. Thus, it investigated. It does not mean that the impeachment proposal is inappropriate. 3. The principle of non-repetition. This was a rather strong argument. The National Assembly Act stipulates that a rejected proposal cannot be reintroduced in various sessions. So Professor Lee Gyo-woo from the Chungang University School of Law also argued that this violates the principle of non-repetition, so it should be dismissed, as I recall. The respondent is President Yoon Suk-yeol. The first impeachment proposal did not reach a vote during the regular session. But what happened next? The next impeachment proposal was introduced during an extraordinary session. The session changed. Therefore, it was considered not to violate the principle of non-repetition at that time. However, there is a supplementary opinion by Justice Jung Young-sik. Justice Jung Young-sik is also considered a conservative judge. Though it's a bit of a stretch to label him as conservative from the conservative side. In any case, those who protested against the impeachment had high expectations for Justice Jung, but it ended with just a supplementary opinion. So, there is a need for legislation to limit the number of times an impeachment proposal can be introduced. Since we can't keep proposing impeachments endlessly, let's limit the number of times it can be introduced. Let's enact such legislation. This was the extent of the supplementary opinion. It shouldn't lead to dismissal. The impeachment is dismissed. That was not the opinion. Now, the the martial law was lifted in a short time. In discussing why it was imposed, I also mentioned this in my first live broadcast. And if you look at my column, I mentioned that the administration would end up being ridiculed. Since no harm was caused by this, was there a lack of protective crisis, honey? Since there was no harm, they argued that there was no interest to protect that warranted impeachment. This argument was made by his defense team. Even if the accusation is lifted, the grounds for impeachment have already occurred due to the accusation. The accusation has already been made, even if it is lifted later. Once a crime is completed, even if you stop the crime afterward, isn't it already over? Therefore, the accusation has already been made, and thus the grounds for impeachment are already established. It cannot be seen as invalidating the judgment. This is how it turned out. Now, this was another key point. What was it? Initially, the resolution for impeachment included acts violating the criminal law, such as treason. However, after filing for the impeachment trial, they argued by incorporating it as a violation of the criminal law. So, they removed the treason charge, making it like a bun without filling. Was it like noodles without the sauce? That argument was made a lot. So, treason was the biggest issue. Why remove the treason charge? But treason is a criminal matter, so it should be contested in a criminal trial, and the constitutional trial needs to proceed quickly. That's why this is important. The basic facts are the same. Whether it constitutes treason or not will be determined in a criminal trial, but in any case, the evaluation of the facts regarding the declaration of martial law and the mobilization of the military and police by the National Assembly is the same. Therefore, since this does not involve withdrawing or changing the grounds for prosecution, it is considered permissible. This was also the case during former President Park Geun-hye's time. If the grounds for prosecution are partially based on the same facts, it is considered the same as the charges, which is something we often learn in criminal procedure law. Since the basic facts are the same, it was viewed that removing the charge of insurrection from the grounds for prosecution when filing for impeachment is not an issue. This part was mentioned. This was something said by the People Power Party, claiming that if the charge of insurrection hadn't been there, they wouldn't have joined the Democratic Party in voting for the impeachment. But that's hypothetical. It's merely a hypothetical claim, suggesting that if this had happened, then that would have happened. This cannot be objectively supported, so it's not valid. If the People Power Party had said that without the charge of insurrection, they wouldn't have pursued impeachment. If they had delivered a speech based on that, then it wouldn't be a hypothetical claim. Then there would be grounds to support it. But since former Representative Han Dong-hoon and the People Power Party members who supported the impeachment were of the opinion that impeachment was necessary, they did not submit any written rebuttals or evidence on this matter. The impeachment power was abused to seize presidential authority. This is an abuse of rights. There were such discussions, but it was considered that the process of passing the impeachment bill was lawful. Then, since the allegations against the impeached and the constitutional violations were substantiated to a certain extent, it was called substantiation, not proof. Since I specialize in provisional dispositions, this comes out strangely. In legal trials, the judge comes out decisively like this. Since it was substantiated, it is not an abuse. Therefore, the request for impeachment trial in this case is lawful. Simply put, if the request for trial is illegal before entering the merits, they wouldn't proceed with the substantive judgment on the impeachment trial. However, since the request is lawful, they will now proceed to the substantive judgment. That's how it turned out. The rules of evidence were also significant. I pointed this out once back then, and many others have noted it as well. I specialize in criminal law, as you know. In criminal procedure law, if a suspect's interrogation report, prepared by the prosecutor, is denied, you have to call the person and conduct a witness examination in court. However, they just acknowledged it by looking at the interrogation report that was written. At the Constitutional Court, they questioned why even the legality was being violated, and this was pointed out by a very famous constitutional law professor from Yonsei University, Professor Heo Young. They were saying that even the legality was being violated. In the Supplementary Committee of Imseon and Kim Young-do, it was stated that the rules of evidence in criminal procedure law could be relaxed and applied in constitutional trials, impeachment trials. Why? Because impeachment trials are not criminal punishments, but rather disciplinary actions against public officials. So it's a bit different. That's how it was viewed. Imseon must feel relieved. Leaving on April 16th or 18th, right? However, there is a need to apply the rules of evidence more strictly. The part where it was said like this, Kim Bok-hyung, Jo Han-chang, the conservatives said these people would dismiss it, but I thought they wouldn't dismiss it and that it would be fully accepted. However, these people believe there is a need to apply it more strictly than the rules of evidence. These two are in conflict. This is how values diverge. I mentioned before that if everyone's values were the same, we should let AI handle the trials, right? So, you can see the value judgment in this part. In the past, when submitting documents to the court in Korean, I didn't like it, when they were cut off like this, so I divide them like this. Now, let's get to the main point. Since it's legal, then the respondent is President Yoon Suk-yeol. We need to determine whether his execution of duties violated the constitutional laws and whether the violation is serious. We are now examining whether it is serious enough to warrant dismissal. According to the grounds for impeachment, the National Assembly's Judiciary Committee passed a resolution stating that due to these wrongdoings, there was a violation of the Constitution and laws, and since it's serious enough to warrant dismissal, please dismiss him. This is what they have presented. There are mainly two issues. One is the declaration of martial law in this case, and I mentioned that this is the most significant. The deployment of military and police by the National Assembly was broadcast worldwide. It's undeniable. And the proclamation was issued. The proclamation was a bit strange too. Then they went to conduct a search and seizure on Juwon Seongun. Attempt to verify the position regarding the legal community. Looking at these 5 points, the verdict is delivered with the unanimous opinion of the court. The order is to dismiss the president's authority. That's how it turned out. These 5 reasons were viewed this way by the constitutional judges, but your opinions might differ, and you can criticize it. Regarding the decision, however, criticizing is one thing, but destroying everything is truly an insurrection. Absolutely, 문종탁TV subscribers should not do that. Good morning, CC Bell. Have a beautiful day. Peace and love, handsome. Thank you, wise solitary life. In reality, I look like this, but it seems poor when you see it like this. Right now, with the chroma key effect, my face looks completely swollen and strange, but thank you, wise solitary life. I hope there will be an opportunity to see me in person someday. And as for CC Bell, you seem to be a foreigner. Hi, CC Bell. Nice to meet you. As you know. This is Kim Soo-hyun. I posted this in English, and it seems many overseas people subscribed, so you might have come across it, but I'm not sure if you know about this. Since you told me to stop talking nonsense, the number of concurrent viewers has increased a bit. Alright, then, let's get into the main topic. Even if you want to criticize or oppose the Constitutional Court, you need to know what's wrong to do so, don't you? And you might even agree that it's reasonable, but you need to know first. Now, where were you all when the martial law was declared in this case? I also saw it on TV. The president suddenly declared martial law. Someone came out, pulled a chair, and sat down. But according to the Constitution, and the constitutional law, it's the rule of law, right? Even the president must follow the supreme law of the Constitution and the constitutional law. There are substantive requirements for declaring emergency martial law. There are substance and procedure, but let's look at the procedure first. One of the substantive requirements is what? It must be during a war, an incident, or an equivalent emergency situation, where there is a state of conflict with the enemy, or the social order is extremely disrupted, causing practical difficulties in performing administrative and judicial functions. This must be present to declare emergency martial law. Everyone was comfortably at home, and I was lying down watching TV when I suddenly saw it, but it wasn't that kind of situation. However, the respondent, the president, is making this claim. The opposition party, in a majority fact, is unusually pushing for impeachment proceedings in the National Assembly, which is actually wrong. They are unilaterally exercising entry rights and attempting budget incidents, and this is a serious crisis situation. The respondent, this is a serious crisis. Is this a high-level governing act or a high-level judgment? We saw it earlier in the procedure. If this also violates the Constitution or laws, it means that judicial review can determine whether this judgment or action was wrong. It means it can be subject to judicial review. That's why we are conducting judicial reviews. However, after the approval of the defendant, before the declaration of martial law, the Minister of the Interior and Safety, the Chairman of the Korea Communications Commission, and the Auditor General proposed 22 cases of carbon loss. This was a mistake. This was pointed out again. Judge Moon Young-bae also mentioned that although there is much talk about the impeachment, the National Assembly raised concerns by not thoroughly considering the unconstitutionality and illegality of the impeachment charges, focusing only on the suspicion of legal violations. This was acknowledged. However, this is always important. But, the construction we were worried about has begun. Well, you might hear some noise over there. Can you hear it? A lot? Is it very disruptive? It would be fortunate if you can hardly hear it. If you do hear it, we ask for your understanding. Even though there is construction going on around me, I am doing this because it is important. However, at the time of the Constitutional Amendment Proclamation, there was only the impeachment review process for one prosecutor and the chairman of the Defense Committee. Was the Constitutional Amendment Proclamation on December 3rd? Yes. At that time, only the prosecutor's work and the review process for the chairman of the broadcasting committee were underway. At that time, only these two were suspended from their duties. Later on, any other impeachments or such happened afterwards. And the bills that were claimed to have issues due to being passed unilaterally. It was the opposition Democratic Party, or other parties, proposals and demands. This is the veto. Postponement of promulgation. So, the legal effect had not yet taken place. It wasn't something to be stopped by martial law. And who created the opposition like this? In fact, Yoon Seok-yeol, during the general election at the time, made strange statements about the big wave, and he was a president who didn't serve in the military under the guise of justice and fairness, but became a star prosecutor by sending former President Park Geun-hye to prison. However, regarding his wife, he privately protected her one by one, and there were many issues. Forcing the appointment of the ambassador to Australia and allowing the opposition to pass things unilaterally were also in fact due to Yoon Seok-yeol. Anyway, let's set aside that political matter, and regarding the budget, the 2025 budget, during the constitutional amendment announcement in 2024, the 2024 budget was being executed. The 2025 budget is a matter for the future, and since it hasn't even been decided in the plenary session, it's not something to declare an emergency constitutional amendment over. Therefore, since the exercise of authority by citizens over the impeachment, legislation, and budget by the National Assembly did not realistically create a significant crisis, at the time of the constitutional amendment announcement, it was considered a violation of substantive requirements. Now, it seems unlawful and unjust under the authority of the National Assembly, doesn't it? However, it goes like this. First, in the impeachment trial, since it can be addressed through the usual exercise of power, such as the respondent's proposal and request for legislation, yes, this refers to the president exercising a veto. The National Assembly has initiated many impeachments, but I understand that the exercise of veto power has also been at an all-time high. Yoon Seok-yeol. The exercise of national emergency powers cannot be justified, so this is also seen as incorrect. Now, the respondent's denial and suspicion. This is a bit, in fact. It's hard to see this as conservative right-wing, but if that's the case, how did Yoon Seok-yeol get elected? And this implies that a large-scale fraudulent election must be orchestrated. But if I have the opportunity later, I will discuss this in a joint broadcast with an election commission official. There are even lawyers making money off of this, but it's good to resolve it. However, they say martial law was declared to resolve this case. But did a significant crisis situation actually occur as a suspicion? If that were the case, they should have revealed what was involved in the election fraud, not just suspicions. If there were evidence of election fraud, there might be a possibility to declare martial law with legitimacy. Looking at the election, the Interim Election Committee has measures like 24-hour CCTV footage disclosure and introducing a hand-counting system before the vote count. These measures suggest that declaring martial law is not the only way to resolve suspicions. They concluded that a crisis situation did not exist at the time of the martial law declaration and questioned why martial law was considered so serious. The military was deployed because military fatigue was necessary. However, given the authority of the National Assembly, the state of national paralysis due to election fraud suspicions should be resolved through political, institutional, and judicial means. Therefore, it is not something that can be resolved by mobilizing military forces. If you are going to mobilize force like this, is this democracy? It's being controlled by the military. Therefore, this talk of warning type or appeal type enlightenment order, Attorney Kim Gairi mentioned something like that, is enlightenment. The purpose of the constitutional amendment law, no, it is not. It has become a confession of violating the constitutional amendment law. I think Attorney Kim Ga-il is a competent lawyer. Therefore, it wasn't because he didn't know, but because constitutional trials require political judgment. And for public opinion, you need to do that to have momentum. So I think he went that route, and I believe it was an attempt to try everything possible as a lawyer. So a warning type constitutional amendment or an appeal type constitutional amendment is not for the purpose of expanding the scope of the amendment, nor is it to enlighten the public through martial law. Then if everyone in the nation had spoken up, that would have been enough. This was too much of a blow. You shouldn't stab a child with a knife just because they did something wrong. You should scold them. And if they don't listen, have them stand with their hands up. That's something you can do to that extent. So, calling it a warning type or appeal type is not appropriate because it involved mobilizing the military and police to obstruct the exercise of parliamentary authority, and even violated the Constitution and laws. It cannot be seen as a warning type or appeal type constitutional amendment. Thus, the proclamation of the constitutional amendment violated substantive authority. This is how the judgment was made. Did the proclamation comply with procedural authority? The proclamation of the amendment and the appointment of the amendment commander must go through the deliberation of the State Council. What was wrong with the amendment commander? He was the army commander. He seems like a nice person. Park Wan-soo, was he a commander? He was someone who appeared on TV before. Do you think he took on this role because he wanted to? The president suddenly appointed the martial law commander, so it feels like a surprise, right? Now, it is acknowledged that just before the proclamation of martial law, the Prime Minister briefly explained to these people, but the however is always important, right? So the lawyer said, let's see if this went through the deliberation of the State Council. But here it shows that the procedural requirements were violated. Why were they violated? Yes. The specific details of the martial law were not explained, and the other members were not given the opportunity to express their opinions, so the deliberation was not properly conducted. Deliberation means making a decision after careful consideration, but they just notified them, suddenly went in and announced it, and then the Prime Minister and related department members did not sign the proclamation. This is how you write a signature, claiming they reported it and would take responsibility. Documents are important, and they didn't announce the admin arrangement or inform the National Assembly. The notification only came out with the broadcast. There are some doubts about this part, but in any case, it was seen as a violation of procedural requirements. This part is really painful, deploying military forces to the National Assembly. This isn't the Spring of Seoul in 1980. So, almost 45 years have passed since then, and this is correct. The Minister of Defense was instructed to deploy the military to the National Assembly. The military is meant to protect our country from enemies. The National Assembly, along with the President, is the place with the greatest democratic legitimacy. Who elected all the members of the National Assembly? The citizens, including the viewers of 문종탁TV, elected them. You all saw this, right? A helicopter is coming. I thought they were filming a special forces unit. I shouldn't criticize the 707. We shouldn't blame them. They went according to orders and acted passively here because I mentioned that the members of the National Assembly were not arrested. You saw them breaking the glass and all that, right? They broke the glass and went in. Anyway, they went in with guns, and this part will be properly addressed in the insurrection. Was it the commander of the Army Special Warfare Command who approved all these special operations? Since the resolution wasn't passed, break down the door and bring out the contents. This was testified by the Army Special Warfare Commander. What did the Commissioner General of the National Police Agency do wrong? I felt really sorry for this person. Yes, I heard it was blood cancer, but they informed the martial law commanders of the proclamation. They called directly. It seems the Commissioner General of the National Police Agency also stated that they blocked access to the National Assembly. Some members of the National Assembly climbed over the wall, and while some were mistakenly reported, there were also shouts to open the doors, and all of this was broadcasted. The Minister of National Defense and the Commander of the Defense Security Command, they are seniors and juniors from the same school here. Is the state a joke? It is confirmed that the Speaker of the National Assembly and the leaders of each political party were instructed to verify their locations, although the claim of self-defense was not accepted. It is also true that they told the Deputy Director to provide support. Since there is a sharp dispute over the request for location verification, this will be addressed when determining whether it constitutes rebellion or not. In any case, the National Assembly has the right to demand the lifting of martial law. The National Assembly can demand the lifting of martial law when the President declares a state of emergency. There needs to be a check and balance. It grants the National Assembly, which has legitimacy comparable to the President, the right to demand the lifting of martial law, but trying to prevent that by controlling the access of members of the National Assembly and ordering their removal infringes on the immunity from arrest and the voting rights of the members. It also infringes on the freedom of political activities. Now, this is another key point. The military, whose mission is national security and defense, was made to confront ordinary citizens. For political purposes, to block the exercise of the National Assembly's authority, troops were deployed, tarnishing the honor of the soldiers and making them act against their duties. They were made to do things contrary to their obligations. Since the President is the Commander-in-Chief, he should take responsibility for his subordinates being in a difficult situation. Therefore, the political neutrality of the military is extremely important. However, it is said that the military was used for its own political purposes. Therefore, it violated the constitutional duty of commanding the armed forces. At this point, our country is a divided nation. And because of that, I personally think it would be good if people who have served in the military became president. Now, the third proclamation. Since the proclamation itself was left as a document, you were sitting there reading it. This is undeniable, right? What does it say here? Oh, it was really a comedy. That's not here. It says if the resident doctors don't come, they will be punished. It seems they were too embarrassed to write this, so they didn't. Therefore, the decree prohibited the National Assembly, local councils, and political parties. You can't prohibit National Assembly activities under martial law. Lifting martial law is the National Assembly's authority. It violated constitutional provisions regulating the party system, democracy, and the principle of separation of powers. The president is, us, discussing punishment, violates the principle of warrant, and infringes on the people's basic political rights, the right to collective action, and the freedom of occupational activities. The freedom of occupation could relate to the medical residents. Yes, there are conspiracy theorists, election conspiracy theorists. The election official in Korea was subject to a search and seizure. A search and seizure should be conducted with a warrant issued by the court. But how was it done? When the Minister of Defense is involved, there should be a warrant for search and seizure, and the judiciary should verify and provide a check, right? If the president doesn't agree, they just go and search their house. Hey, conduct a search and seizure there. Then why do we need the court? Why do we need the principle of warrants? Yes, it's to protect personal freedom. It's a way for human rights to develop and the process of moving towards modern law. Therefore, the Central Election Commission is also a constitutional body. They seized the phones of the party members here without a warrant. They filmed the computer room without a warrant, violating the principle of warrants and infringing on the Election Commission's video. Attempting to verify the position of legal professionals. I am also a legal professional, but I'm not that well known. Here you see former Chief Justice Kim Myung-soo, but this person does have some issues. And former Supreme Court Justice, I'm not sure if it's Justice Kwon Soo-nil from the 55 Club, but I think there are many people with issues. I do. However, even so, arbitrarily verifying locations and putting pressure by suggesting judges can be arrested at any time undermines the independence of the judiciary. In colloquial terms, birds of a feather flock together. And naturally, judges tend to side with each other, as constitutional court judges are also judges. However, if the president starts verifying locations with the intent to arrest even the Chief Justice and Supreme Court justices, it is seen as infringing on the independence of the judiciary. It seems that many have turned away at this point. So, then, is the legal violation serious enough to warrant dismissal? The answer is already clear. As I'm listening, having discussed this much, you can't say it's not serious. Otherwise, it would be a contradiction in terms. Do you see things like silent screams these days? It has completely collapsed. Thank you for your hard work. I'm so sorry for the inconvenience. Like this, Jeju Island, my maternal family is also from Jeju Island. But it's interesting. It was interesting at first. As IU changed to Moonsori, she kept cooking and doing laundry for the kids too much. Selling the house and taking care of her grown-up daughter. I couldn't watch it because I've never experienced such things. As it progresses, the narrative is really good. It's tough, but they try to live on, sacrificing themselves and such. I recommend it. Why am I talking about this? The silent scream of contradictions comes up. I won't say more to avoid spoilers, but have I already said too much? IU and Park Bogum, during their childhood in Jeju Island, IU was a literary girl. The vivid image of a silent scream is poetic, but to this extent, violating this and that, violating the constitution and the law, everything has been mentioned, so they wouldn't say it's not serious. But let's see why it's considered serious in conclusion. Now, with the intention of resolving the confrontation with the National Assembly, they denied the principle of national sovereignty and democracy, deployed military forces to conduct searches and seizures, disregarded the constitutional governance structure, and broadly infringed on the people's rights through the proclamation of martial law. This is a case of insurrection. However, in any case, the proclamation of martial law prohibited political activities and threatened punishment if not complied with. There is a problem. Such actions themselves infringe on constitutionalism and pose a serious threat to the stability of the democratic republic. Now, the National Assembly demanded the lifting of martial law, right? What was the reason they were able to do that? Did President Yoon Suk-yeol say, now that it's open, withdraw? Is that how it happened? No, it wasn't. The citizens resisted. When they set off fire extinguishers in the National Assembly, I actually thought it was tear gas. They certainly had the capability to do it, because they were anti-terrorism suppression units like the 707 Special Forces. But they didn't do that. It seemed like the aides were the ones setting off the fire extinguishers. Anyway, the citizens resisted, and people were going out in front of the National Assembly at that time. And the military and police were performing their duties passively. I mentioned there were few people, but what about the guns? Why were the planes able to crash into the Twin Towers during the 9/11 attacks? Because they threatened with guns and knives at the World Trade Center. Even with a much larger number, such neutralization and suppression are possible. That's what's frightening about the military. When holding lethal weapons like guns, just firing above, with a rat-a-tat-tat, everyone would kneel down, right? If just one person is shot and killed, everyone is subdued. But they didn't do that. They were very passive. There was also a strange woman, whether she was a successor or a spokesperson who was holding a gun, was so and acting as if she was taking it away, kind of overacting. In wartime, they would just shoot and kill. But they didn't do that, did they? So I fully understand this part thanks to the passive duty performance of the military and police. Because of this, they were able to resolve to lift martial law. That's why they lifted it. The statement that it does not affect the assessment of the seriousness of the respondent's legal violation was concluded quickly. Saying, didn't they lift it, is not acceptable. The reason for lifting martial law was due to the citizens' resistance and the passive duty performance of the military and police, not because the president intervened. If that were the case, it would have been martial law. Is the president a god? Is the president a king? Then we would be a monarchy. It's not a republic. The president's authority is granted by the Constitution. The national emergency powers must be exercised with utmost caution because it restricts the basic rights of citizens and involves military mobilization. However, by exercising it beyond the constitutional limits, it led to distrust in the exercise of presidential authority. Didn't people start fighting over this, splitting into pros and cons, causing a commotion? In many impeachments, the exercise of authority by high-ranking officials was suspended during the impeachment trial. I understand this. The opposition party decided on it unanimously. This was also a mistake. And the impeached president tried to do something, but it couldn't be implemented due to opposition from the opposition party. The opposition party was made so large, but the president called it a general election blunder, as I mentioned. But putting all that aside, even if one perceives that the government is paralyzed, or national interests are being harmed, one can feel a sense of responsibility. This was acknowledged as being sufficiently done, but the however is always important. However, but is the conflict between the impeached president and the National Assembly solely the fault of the National Assembly? And what is democracy? Is it a problem that should be solved politically, or should it be resolved by deploying the military and declaring martial law? Yes, so it should be done in harmony with democracy as guaranteed by the Constitution within that scope. The National Assembly should also respect minority opinions, and although it's a bit of a sad situation when the ruling party becomes the minority in its relationship with the government as well, it should have made efforts to reach conclusions through dialogue and compromise. So it's saying that the National Assembly didn't do well either. However, the impeached president should have respected the National Assembly, which represents the people, as a partner for cooperation. The impeached president completely ignored the National Assembly. I understand well enough that you don't like Lee Jae-myung. However, if things continue like this, Lee Jae-myung will likely become the most prominent candidate for president. And it's Yoon Suk-yeol who made it this way. The final president should have respected the National Assembly as a partner for cooperation as well. But he ignored it and didn't even look at it at all. Such pettiness and stubbornness are seen as having created extreme political confrontation. It means that the National Assembly was treated as something to be excluded. It's seen as undermining the entire political system, making it hard to view as harmonious with democracy. I think it was really well written. Even if it was judged as tyranny of the majority, the balance of checks should not be martial law, but the Constitution's block. In the parliamentary election held 2 years after the inauguration, as I mentioned, there was an opportunity to persuade the public to let the elected representatives lead the government. It wouldn't align with the intentions of the elected representatives, since it became a minority government. However, they should not have attempted to completely exclude the will of the people who supported the opposition. The people's will was with the Democratic Party, but artificially using the military to intervene was wrong. Nevertheless, it replicated the history of abusing state institutions. Yes, it repeated a history that was not good in the past. It shocked the public and caused chaos in society, economy, politics, diplomacy, and culture. It's true that it led to confusion in all these areas. He is the president of all the people. Not just the president of the People Power Party, nor just the president of the Yeongnam region. And because of that, was it 51% who voted for him? There wasn't much of a difference. He has the responsibility to integrate even those who support the Democratic Party into the social community, but he violated that duty. This is the core issue. By mobilizing the military and police, he undermined the authority of constitutional institutions like the National Assembly and violated the basic human rights of the people, thus gravely betraying the trust of the sovereign citizens of the Republic of Korea. It's regrettable. In the end, the respondents' illegal actions betrayed the trust of the people. From the perspective of constitutional ownership, this constitutes a serious violation of the law that cannot be tolerated. It is indeed serious. Therefore, the negative impact on constitutional order and the severity of the breach mean that the constitutional benefit gained from dismissing the respondent is much greater. The national loss resulting from the president's dismissal is overwhelmingly significant. And this is the reason. The respondent is the president, and the violation of the law includes the Constitution, the amendment law we saw earlier, the National Assembly Act, and various others. The violation is so serious that it warrants dismissal. Therefore, the The constitutional benefit of dismissal outweighs the national loss resulting from the president's dismissal. This is what I anticipated. The judgment is pronounced with the unanimous opinion of the court. I will confirm the time of the announcement for the impeachment case. The current time is 11:22 a.m. The current time is 1:02 p.m. I pronounced the judgment, and without eating, I worked from 12 calls to 1 call during the lunch hour. Those of you who watch this without having lunch are amazing, and I see that all our readers are outstanding. Thank you, Mr. Lee Jong-moon. I am enjoying the clear and delightful legal content, as expected during the broadcast. Yes, thank you. I will edit and upload it well. Adjusting the spacing is really thrilling. This spacing adjustment is used by people who are good at using Hangul files. I write like this, so I really dislike it. There's just one thing, but everything else fits in. Where is this? You can reduce these things to one line, but then it becomes too small, right? That's why I prefer to extend it a bit. Just seeing violation. Like this is unpleasant, so I make it clear with violation. The reason I can laugh is because I need to look to the future. With this, don't ignore the Constitutional Court's decision and start talking about things like martial law. Criticize the report. If there are mistakes, what aspects can be criticized? What do you think? What went wrong? Let me summarize briefly. It becomes subject to judicial review. Then, the impeachment trial is set to protect the constitutional order against violations of the Constitution and laws by high-ranking officials. But then they say it's all a political decision. Why are you making a judicial judgment? How do you make a judicial judgment in this case? You can't do it, right? Then, if they become high-ranking officials, they'll just do whatever they want, as they say in slang. So, of course, it becomes subject to judicial review. Talking about acts of governance itself is a pre-modern way of thinking. The National Assembly can do this without Legislative and Judiciary Committee investigation. The National Assembly handles impeachment alone. It was reintroduced when the impeachment motion was proposed. But Jeong Yong-sik, the supplementary officer, he was a hope to conservatives, but he suggested legislation to limit the number of times an impeachment motion can be initiated. He just gave this opinion. There was no objection to the idea that Yoon Suk-yeol should be dismissed because he violated the Constitution and laws in a serious manner. Fourth, since martial law was lifted in a short time, isn't there no need for protection because there was no harm? Even if it was lifted, martial law was already declared. Therefore, since the grounds for impeachment have already occurred, how can you say it didn't happen before? The fire has started. It's already been wandering. Putting it out quickly is a matter for later discussion. Now, this part can be criticized. So, it was a mistake to include the charge of insurrection in the initial impeachment resolution. It should have been removed, but that shows how incompetent the Democratic Party and the Judiciary Committee are. However, just because they were incompetent doesn't mean the impeachment was entirely unfounded. Why? Because the basic facts remain the same. Yoon Suk-yeol declaring martial law and sending the military to the National Assembly and the Election Commission is the same story, whether to include or exclude insurrection there. This is like saying, since they made such a comparison, it's like this in a figurative sense. It's like saying there's squid in the jambong, but take out the squid and eat it. Jambong is still jambong. So, did they abuse the impeachment process to escape their position? Did they use the impeachment process unlawfully, like a president? I mean, did they do it like an illegal martial law declaration by a president? It was done legally through a resolution with some members of the People Power Party agreeing to it. It was not proven, but rather explained. Therefore, it cannot be seen as an abuse of the impeachment process. So they actively pursued it in the court of judgment, and the rules of evidence in this part can be criticized. They applied the Criminal Procedure Act, but relaxed the rules on hearsay evidence. This is something that can be done, as stated in the supplementary opinions by Imi Seon and Kim Young-do. Later, please obtain and read them in detail. In impeachment trials, there is a need for strict application. However, going forward, yes, from now on, let's do more. Although you expected more from Justices Kim Bok-hyung and Jo Han-chang, it was only in the supplementary opinions. So we looked at whether there was a constitutional violation, whether there was a dismissal, or whether it was prepared. It didn't meet the substantive requirements for a constitutional amendment declaration, right? Only one prosecutor and the Broadcasting and Communications Commission faced impeachment. Later, a suspended sentence case arose. And if not, even before that, the budget was the same. So was there a need to respond to actual requirements of military force and military necessity? It couldn't be resolved by mobilizing military force. And there was a warning type, appeal type martial law. This is not the purpose of declaring martial law. So, things like the martial law order were not the purpose of declaring martial law, but it was a mistaken argument. So, it was declared as emergency martial law in violation of the actual requirements. Thank you. Why solitary life? Why solitary life? You are also living wisely alone, right? As I live wisely alone, I think I can do this. Now, did we comply with the procedural conditions? And please promote this a lot. I will upload it after the live ends, so please share it widely. Among lawyers, I seem to be the fastest. Among legal professionals, isn't that right? This is like the judgment document. I summarize and organize the judgment points, and then immediately work on the document. Isn't that right? Thank you. At least as a lawyer, I will provide legal information. But enlightening someone, or things like that, honestly, my level is quite average, isn't it? Confucius? Things like that. Yes, I did the 1,000-character classic when I was 5 years old. I studied the 5 basics and read things like the Analects of Confucius in elementary school. We are not studying Joseon Dynasty Neo-Confucianism these days, but the Analects of Confucius is a classic. They are classics, so they are important. But the concept of cultivating oneself and governing the family also appears. One must first cultivate oneself. One must govern their own household first. I think I'm not qualified to discuss governing the world, but if someone is qualified, they should do so. But as I mentioned, at least my subscribers should know the basis of today's significant impeachment decision, so they can discuss it with others. That's why I'm doing this. Spreading knowledge is one thing, but thinking you can tell fully grown adults how to live or change them is arrogance, in my opinion. Who are they trying to enlighten with these appeals and enlightenment orders to the National Assembly? This kind of arrogance must be where it comes from. The self-righteousness of believing only one's own view is correct. I think these are the essence of this tragedy. They couldn't even comply with procedural requirements. It should have gone through a cabinet meeting review, but a brief explanation? They just notified and went ahead with it. So they also triggered procedural issues. Especially, how long has Han Duck-soo been a public official? It's been quite a long time. He didn't want to get involved, so he didn't take part. Now the people who were involved and defended it are in chaos. So the deployment of military and police was broadcasted worldwide. This is undeniable. It ended with just this one thing. While doing a live broadcast that day, I questioned what wrong the 707 unit did by being deployed to the National Assembly. It was said that the National Assembly, which the people elected to fight terrorism, especially the National Assembly, has the power to lift martial law. Since they can lift martial law, that's why they were deployed. Who maintains order at the National Assembly at night? No one was at the National Assembly. Everyone was at home and only went to the National Assembly then. With no one there, why deploy troops to maintain order? It doesn't make any sense. Bring out the helicopters, break the kindergarten, and all these special operations commanders should be charged with treason? But the fact that military and police were deployed to the National Assembly is the main issue here. Can you change this? You can't change it. In trying to justify this, all sorts of absurd arguments are being made. The demand for pirate rights at the National Assembly violated the Constitution. It infringed on the privilege of immunity from arrest for members of the National Assembly. It also infringed on the freedom of political party activities. Thus, it violated even the duty of military command. Proclamation? Even looking at the proclamation, it's a comedy. Yes. Did they not review it before presenting it to the public? Yes. It's really nonsense who wrote that for the National Assembly, but it's believed that Yoon Seok-yeol wrote it. If you try to find any merit in the Minister of National Defense, it seems he has some loyalty, trying to take the blame. But if the person who was president has any conscience, they should take responsibility, acknowledging that their subordinates ended up in trouble because of them, saying it was done because he ordered it. The conditions for constitutional amendment were granted by the Constitution. There are also constitutional provisions for the party system, representative democracy and separation of powers. What is the separation of powers? While the president holds the presidency, the National Assembly is supposed to check the president, but all of that was violated. So, the issuance of the emergency decree itself, especially threatening to punish if the medical residents don't come, is quite a comedy, and this itself is a violation of the Constitution and the law. If you want to conduct a search and seizure for a manipulated election, obtain a search and seizure warrant from the court. This also undermines the independence of the Election Commission. This doesn't mean the Election Commission did well. Election Commission, do your job properly. This part is also crucial for legal professionals. Local judges feel this kind of fear. They can be arrested and replayed at any time. This shouldn't be happening. The seriousness was already concluded with what we reviewed earlier, but they say they will review whether it's serious again, so they keep talking about it. It broadly infringes on the basic rights of citizens with the issuance of arrest warrants. It's a dangerous scope. There hasn't been a direct arrest of citizens, but the fact that they could demand a resolution was thanks to the passive performance of duties by the military and police, not because the president did anything. Therefore, by acting beyond the limits set by the Constitution, distrust was caused, and eventually, these kinds of statements are being made. The Democratic Party also made mistakes, as did the National Assembly. However, it's not solely their responsibility, and according to the principles of democracy, shouldn't there be dialogue and persuasion between each other? And shouldn't the National Assembly be respected as a partner for cooperation? And if you've messed up and the opposition party is gaining more support, are you going to completely exclude that from the People's Power Party? That's what has come out. So the entire nation is in shock, affecting society, economy, politics, and diplomacy. Especially in diplomacy, right? With Trump in the situation, we can't even hold a normalization summit. It's been messed up. And it's not just about those who support you. The social community needs to be unified. But what is it now? Even those who took action are divided into pros and cons. Even the lawyers. Among the lawyers, can you see this? This matches the Constitutional Court's color, purple. When red and blue mix, it becomes purple. This was done to symbolize unity and harmony. Even if Yonsei comes out in blue, when Yonsei and Korea University have their rivalry, you let it slide a bit. Do you kill Korea University students because of that? That's not the case. There are limits, right? If things go wrong, you might mock or jeer at each other. But to beat someone and cause injury, to stab and kill with a knife, that's a crime. It's serious, isn't it? Deploying military and police to the National Assembly? Does that make sense? Then why hold elections? Just take control of the military and wipe out all the opposition. So, it's a serious violation of the law, in conclusion. Yes. As we saw earlier, the respondent, President Yoon Suk-yeol, has committed acts that are too negative and obstructive, violating the law and the Constitution. So it's much better to dismiss you. Goodbye, that's how it turned out. This is important, a unanimous decision. Kim, the reporter, and those who claim to be YouTubers, saying it's 5-3 and that Justice Moon said something about a third, all of that is just speculation. Wasn't my prediction correct? I believed there would be an impeachment. Yep. And you should judge who was confused between hope and prediction. There are people who fail in their predictions. As Go Byun-in mentioned, making predictions isn't really desirable as a legal professional, to be honest. However, because subscribers and viewers are curious and want it, I can make predictions as a legal professional. But if those predictions don't hold, then I just need to acknowledge that my skills are somewhat lacking. As a legal professional, one might think that this would violate such and such constitutional principles. These things would be significant. That's what you know. Martial law? That shows a lack of understanding of the purpose of martial law and the Martial Law Act itself, and is just speaking from a partisan perspective. I don't think that's the right attitude for a legal professional to defend. What do you all think? Anyway, even though it was expected to be dismissed, do we need to appoint people like Ma Yun-hyuk if Lee Jae-myung becomes president? Since it's from the past, wouldn't it be right not to appoint Ma Yun-hyuk as a judge after the tax theory cell meeting? Let's have the new president select new competent people. And the order had is to immediately dismiss the president's authority. How significant is this? Where were you at this historic moment? Were you watching while eating popcorn? Today, April 4, 2025, 4.4, at 11:22 a.m. The timing is exquisite. It was the first, but it became 2.2, from 1 to 2, and even the human character is 2. I hope everything becomes 2.2, the ruling party, the opposition, left, right, progressive, conservative, freedom, equality. From the first Mochoi to 2.2 at 11:22. What did President Yoon Suk-yeol say? President Yoon Suk-yeol, who is like a gun muzzle, will be dismissed. I've explained the reasons more thoroughly than anyone else. If you found this helpful, please subscribe, like, and share it with those around you. And if you share it, I will provide the explanation. I cannot persuade. Can persuasion happen when the sword of knowledge claims it will persuade itself? Since I have explained it, each of you will have your own judgment, right? However, after understanding it rationally, please do not be swayed by demonizing only one side. This has been lawyer Munjongtak from MunJongtakTV. Now it's April. April is a cruel month, but cherry blossoms bloom, and students probably can't take their midterms. I hope everyone returns to their daily lives and lives diligently. That is patriotism. Like the suddenly impeached former president who deployed military forces to the National Assembly and violated the Constitution. If you also step forward and try to overturn the decisions of constitutional bodies or the Constitutional Court, that is chaos. Instead of doing that, I think you should return to your own livelihoods and live happily and diligently. Please also leave your thoughts. You know that I try to reply to each comment. And if I can't, I at least give a heart, right? But please note that I can't give a heart to comments that are too harsh or slanderous. Thank you. This has been Attorney Munjongtak from MunJongtakTV.